Welcome once again to Lehto's Law. Here's Steve Lehto.
Rob sent me a story. Said, Steve, you're always talking about goofy stories, and the question is whether they're true or not, because I got a true one for you from 2005 that'll blow your mind. And it happened in Michigan. It has to do with no-fault insurance. And I've mentioned before that Michigan's got a very unusual no-fault system, such that when I was sitting in my truck minding my own business perfectly legally earlier this year, and someone plowed into the back of my truck and admitted it was their fault because they weren't paying attention, and they got a ticket for not paying attention. My insurance company had to pay for my repairs on my truck. And I've had people say, well, Steve, of course you could sue the person who's at fault. No, not in Michigan. No fault. So they had to pay for my deductible, $500, but the rest of it, my insurance company paid for. So that's how no fault works, and it's idiotic. So when I was talking about some goofy lawsuits that were real, Rob said, check this one out from '05. And it's from the Insurance Journal, but the Associated Press also reported it. Truck insurer ordered to pay for plane damage under Michigan no-fault law, a collision between a truck and an airplane. And the question is, Just so you know, the question is, Two courts of Michigan have ruled that the insurer of a truck must pay $18,000 for damage caused to a small plane that crashed after clipping the truck as the pilot tried to land in a grassy airfield. Now, the truck was being lawfully driven on a road when the two-seat Cessna flipped over it and went nose first into the ground, stopping upside down in the field. The truck driver said he was hauling broken concrete when he saw the aircraft coming towards him and thought, I'm done. Of course, he survived to tell the story, but he was not hurt in the accident that happened just outside of Cedar Springs. Now, the pilot from Jackson, Michigan, and his passenger, who was his wife, also escaped injury. The problem is the airplane did not escape injury. The man who owned the truck said he got a letter from the people in the airplane a few weeks after the crash, and it said a claim was being made against his insurance company seeking payment for damage to the plane because the plane was built in 1974 but totaled in the crash, and planes are expensive. He, the owner of the truck, told the Grand Rapids Press, I think it's absolutely absurd and asinine. It's unbelievable. His insurance company ended up being sued for the plane damage in Rockford District Court. Now, the Grand Rapids lawyer representing the people in the plane argued in court that Michigan's no-fault insurance statute calls for compensation in property damage cases that occur in collisions between motor vehicles designed to be driven upon roads and things that are not, when the collisions do not occur upon roads. So, again, the truck was on the road, but the airplane was in the air, as airplanes are wont to do. And so they collided in some way. And now, I might be thinking about this too simplistically, and I know I've got some pilots in the audience, but it seems to me that in a truck-plane collision, the party that's most likely capable of avoiding that would be the people in the plane. But we'll see how it goes. The attorney said the plane is not a highway vehicle, and since it struck the truck and never touched the road surface, the accident didn't occur upon a road. The truck was on the road, but the accident didn't occur on the road. And they argued about the use of the word upon. And believe it or not, they broke out the dictionaries. This is one of the cases where they broke out the dictionaries. Now, they didn't break out the Black's Law Dictionary. They broke out regular English dictionaries because the law mentions something being upon a roadway. In briefs filed with the court, the insurance company argued that the definitions of motor vehicle and upon a road were too narrow and obviously not what the no-fault statute intended. So the judge sided with the attorneys for the people in the plane. The attorney said the no-fault law is clear in this case, proven by the fact that two judges have studied it and reached the same conclusion. Well, the attorney for the insurance company, who is representing the drivers of the truck, said the system is still a good one for insurance companies and their customers, but some changes are needed. He also said it is unlikely that an $18,000 verdict will prompt his company to fund further appeals or lead to the legislature taking any action. Meanwhile, the man who owns the plane said he's not received the money to replace his wrecked airplane, valued at $21,000. But the truck owner said he now has a $59,000 claim on his insurance record that reflects the cost of defending the case. So, a crazy case. couple things we need to explain here. Truck driving down the road, airplane coming in for a landing, clips it. The owner of the airplane sues the truck driver owner, saying that no-fault insurance covers this. But you might say, Steve, I thought no-fault meant that you cover yours, I cover mine. That's between two vehicles on the road. And the vehicle in the sky is not a road vehicle. It's not a motor vehicle so they're making the argument kind of like if the truck had gone off road and smashed into a building, right? The building doesn't have to insure itself against the truck because the building doesn't carry automobile insurance. And so it just appears as a very strange way you could interpret this law for this unusual set of circumstances. How many airplane motor vehicle collisions occur like this around the state of Michigan? And the other thing that's unusual about this is that because the claim was below the jurisdictional limit for circuit court, it was filed in district court. And district courts take their appeals to circuit court. Circuit court appeals to the Court of Appeals. And so opinions from district court and circuit court are not considered the cases that we cite for precedent as, making new law. So if somebody had wanted to prove a point on this, they could have taken this to the Court of Appeals and appealed it there, but it appears they didn't because there wasn't enough money for either side to do that. But it's a very, very strange outcome. And again, like I said, man's driving his truck down the road, sees a plane coming, plane hits him, and the owners of the plane sue him, and the owners of the plane win. That's what's crazy about the case. So it shows how crazy Michigan's no-fault law is. Again, like I said, the simple concept that you're stopped at a light, someone rear ends you. They are 100% at fault. No question. Your insurance pays for you. Their insurance pays for them. That's the way it is. And I will get comments from people saying, but Steve, obviously you can sue them because it's their fault. No, that's what no fault is in Michigan. You don't sue them for damages to your vehicle. You can only get them for the cost of the deductible. And, in my case, it's $500. So there you go, Rob. That's a great story. Truck insurer ordered to pay for plane damage under Michigan's no-fault law. Happened a couple of years ago, but those are the kinds of wacky things that happen with Michigan's no-fault law. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Mediocrity thrives on standardization.